Thank you, counsel. Well argued. The next case is BOYKIN versus BOYKIN Construction versus GAFFKEN and BARRIGER Fund.
May I, Your Honor?
Sure.
I'd like to reserve, Your Honors, at least 3 minutes, if I may.
Okay.
Your Honors, my name is William Beaver. May it please the Court, I'm here representing BOYKIN Construction in a matter involving the age-old competing interests between a mortgage and a lien with somewhat of a unique twist to it. The background, very briefly, is this property was purchased as Millbrook Manor by the purchaser Platinum Properties to be developed as a residential subdevelopment in Lake County. Ostensibly, Platinum believed they purchased the entirety of about 50 acres. Subsequent to that purchase, they found that 3.6 acres lying situationally almost in the middle had been inadvertently omitted from that purchase. And upon that discovery, they went back and purchased that 3.6 acres.
Is that the little orange sliver that's shown in the appendix?
I believe that's correct, Your Honor. I know which part of the record you're referring to. Yes, Your Honor.
May I just ask, so I have some focus on the statute. For purposes of when the lien attaches, and I know we're going to be debating over to what the lien attaches, but if these are subdivision improvements, then the lien would appear to attach when the claim of lien is recorded.
Absolutely.
And if they are liens of persons in privity under subsection 2 of 71307, they attach and take priority at the time of the recordation of the notice of commencement.
That is correct, Your Honor.
Now, can you tell me which one of those two provisions that you're traveling under?
Yes, Your Honor. If you look at 71304, which is specifically the section addressing subdivision improvements, it says that essentially notice of commencements do not apply to establish priority for subdivision improvements. It carves
So you can see that that's the one that you're traveling under here. Is
for subdivision improvements, Your Honor. But there is no argument that the lien itself was recorded some 3 months before the mortgage in this action.
I understand.
So, okay, Your Honor. When Platinum discovered this, of course, the development would be impaired by not only situationally the property, but the impact on the development itself, so they went back and purchased it for cash. Subsequent to that, they used it to get some operating capital, and they put it up with granting a mortgage and getting a loan from GAFFKEN and BARRIGER, which was, and I have a timeline if the court would appreciate it, but it was subsequent, as we've addressed, to BOYKIN actually recording the lien for his subdivision improvements.
Just as a matter of curiosity, how do we know that they initially thought they had bought all the property and then they found out that they hadn't, and so then they went back and bought the rest of it? How do we know that?
As a matter of record, Your Honor, there's an affidavit from the property owner that describes that. I can get my record materials. I don't have that citation directly in front of me, Your Honor, but it's provided with a citation to it.
And what was the affidavit filed in support of?
Motion for summary judgment.
This motion for summary judgment?
At the lower level, yes, Your Honor. And the question, so subsequent to that, there was an action brought by GAFFKEN to close out their property interest, foreclose their mortgage. Initially, they did not list BOYKIN. The issue in this case is whether the lien that BOYKIN provides the statutory notice required to attach to the property. The applicable mechanics lien statute that defines that is 713-081D, which says it requires that the description of the real property is sufficient for identification. And as the case of Adobe Brick and other states, substantial compliance with that statutory requirement is sufficient.
But here, what we have, as I understand it, is the notice of commencement, and that's apparently what started maybe all of this problem. The notice of commencement says, we've got this big piece which we've called Millbrook Manor, so that the notice of commencement covers all of this, but then it has a specific exception, except for...
Not the notice of commencement, Your Honor, and that's the problem, because the notice of commencement, when it was recorded, the owner went back to the original purchase.
Right.
When they got the, if you will, Brooklyn Bridge and excluding the 3.6.
Right, so everything started with the original purchase, which excluded out the strip.
Yes, Your Honor. Well, I don't know, Your Honor. I don't believe it excluded it. It was intended, and there are affidavits on file in which the owner said, not only did we intend it to be there, before this purchase transpired, they had actually went back to Lake County, and Lake County had actually issued permits and a new legal description, including this 3.6 acres, because Platinum had subsequently purchased it. So the intent was, in the notice of commencement, to include the piece of property.
Well, but I'm trying to focus on what was in the public records. The public records...
Identical to that, Your Honor, in the description, and if I may approach. This is a description that's contained in the claim of lien, which was virtually identical to what he extracted this directly from the notice of commencement. And that is what Florida law says that a lienor is entitled to do. The theory behind that being, lienors are not sophisticated commercial lenders. They are people who have built a business out of building things. And as you will note from the briefs, a lienor is not required to do a record title search. Think of that. If that were true, construction in this state would literally come to a close. A $5,000...
I think it has.
Well, Your Honor is very astute and accurate. But a $5,000 plumbing job would not only take 4 weeks more to acquire the title, but you would have to pass that expense on. It's not record title, it's a different animal. Mechanics lien statutes specifically say a description of the property sufficient for identification. And case law will reveal exactly how that plays out. It is inarguable that this lien, as a matter of record, says the project known as Millbrook Manor. Interestingly and importantly, it also mentions the contract, it also mentions the owner, and it mentions the lienor. So not only does the potential lender have notice of the project itself and the entirety of it, all it has to do during its record title search for a lender is inquire of the owner. What is this? What does it go to? And in balancing or counterbalancing the interest and the equities and the realities, what more could Mr. Boykin have done? There's not another thing under the law he could have done except perform a record title search.
Let me just ask you, though, that this claim of lien, which specifically says, more particularly described in OR Book 2858, pages 544.
Yes, Your Honor.
If someone were to look at the property described in 2858, pages 544, doesn't that legal description specifically exclude the strip?
Inarguable.
Okay. But the way... So, just so I'm clear, attached to the claim of lien, you didn't attach any of that stuff. All you did was refer to it.
It was attached, but the description, as Your Honor points out, excluded the 3.6 acres.
Okay.
Because the description was extracted directly from the notice.
Okay, so if I were to look at the claim of lien that was recorded, attached to this document was the legal.
Yes.
And the legal specifically excludes the strip.
Yes, Your Honor.
Okay. Now, your client probably didn't appreciate what that exclusion meant, but it was clearly there. And clearly, I think we would all agree that if you said to a surveyor, go out and survey this property, can you find it? They could find it, and they could mark that piece is omitted.
Absolutely, Your Honor. But again, the standards for description and for attaching to a mechanic's lien are not record title. I agree, if it were record title, then you have to have an accurate legal description. But again, you're dealing with sophisticated lienors. The mechanics lien statutes were created so lienors could quickly, efficiently, and accurately get an interest in their fruits of their labors and their hard work. And they do it by providing a description of the property, again, 713-08-1D, sufficient for identification. With all due respect, I think it's irrelevant what comes after the project known as Millbrook Manor. It doesn't, anything that comes after that doesn't vitiate that statement. Once you say Millbrook Manor, you're now on notice. And if the court will turn to the case of...
Let me just ask you this. It seems to me that we've got some facts. Some facts help you, maybe some facts help them. On the one hand, I agree with you. Frankly, if all they had said is Millbrook Manor, section so-and-so, that's probably vague, it's probably close enough but vague enough where somebody's got to go out and make some inquiry as to what's actually included. So I think that arguably helps you. On the other hand, when you look at the very next page and you say, but this doesn't include the strip, that doesn't help you a whole lot. Help me understand to what extent, if you've got these two things that are arguably confusing, maybe, ambiguous, because on the one hand you say it's included, the other hand you say, but it excludes it. Your brief seemed to indicate that your client had trucks and heavy equipment, everything running all over the project out there.
There are aerial photographs, Your Honor, that demonstrate at the time he filed this lien, the property had been completely cleared, site prep, and I don't know what familiarity Your Honor has with this, but raw land, trees knocked down,
to what extent, if any, if the recording is designed to give constructive notice, but what about actual notice? I'm concerned. I guess the one area that interests me a little bit is if there is enough of a question, if a mortgagor, if a mortgagee has actual notice that someone else may claim a lien.
May I, Your Honor?
Yeah.
If you will turn to page 10 of their answer brief. And that's the point I was coming up on. Not only do they have constructive knowledge provided by this, not only did GAFFKEN have implied knowledge as a matter of law, they admit they have perfect knowledge. At the bottom of page 10 in their filing, they quote and are trying to distinguish the Sasso case, and they say, particularly apropos to the incident case, the court in Sasso stated, because the notice of commencement filed by Cedar Martin was on record before United filed its mortgage, which is exactly our case, United could have perfected its priority by performing a title search, something one would expect of any mortgage company before loaning money, which we know is not the standard for mechanics lienors. And thereafter, GAFFKEN goes on to say, in the instant case, that's exactly what we did. We performed a title search. However, the claim of lien discovered in the title search did not include the property upon which it loaned the owner money. Therefore, Your Honors, they acknowledge we got the lien. We looked at it. We made a, if you will, cavalier decision that in our legal assessment, Millbrook Manor is not enough. That's not what the law dictates, Your Honors.
Do you think what obligation, they say, okay, we did a title search. We all agree that a title search specifically excludes the strip that's in question here.
But we all agree it says Millbrook Manor, and the case law, Your Honor, if you will indulge me, plays this scenario directly out of Adobe Brick. The case law articulates and talks about the mechanics lien statutes and what it requires. In fact, if you will turn to Adobe Brick, in Adobe Brick,
where in your brief are you looking at now?
Your Honors, that's a case that I supplemented to the court last week. This is the third DCA's holding in Adobe Brick and Supply Company versus Syntex Winston Corporation, found at 270 Southern 2nd, 755. It's found at tab 2 of your binders. The principles in mechanics lien statutes and those articulated in Adobe Brick are virtually directly on point. In fact, the issue in Adobe Brick was the determinative question on this appeal is whether it was an abuse of discretion and error to reject the lien because of an incorrect description of the property in the claim of lien, identical to what we have here. If you will turn to Adobe Brick, Your Honors, what it talks about is that the property description, inarguably, was inaccurate. And the lienor had extracted it directly from the notice of commencement, identical to our scenario. In Adobe Brick, though, it was found that the lien contained a description of the project, Wilton Towers, which was in the notice of commencement. The court said, in answering that question, the court looked at Florida Statute 713.8 and recited the exact standard I've articulated, a description of the real property sufficient for identification. That's found at 757 of the opinion. The Dudley court determined that the lien would be valid even after acknowledging, and I quote, the claim of lien did not contain the correct legal description of the property. The court went on to analyze the property description to the owner and compared it with the property description provided in the contract, and noted that the owner in a Dudley brick, just as in this case, made the mistake in the legal description, but again identified the project, Wilton Towers. That's found again at 757. And there's a brief dissertation, but it says, columnly to the left, it says Winston Towers and through. Now,
Well, isn't the common thread in all these cases that as for the mechanic's lien or as to the owner, that all you have to do is generally describe, because the owner knows what property we're talking about?
No, Your Honor. The record is for those who review the record. And the record, the question is, does that claim of lien provide notice to any follower? And what the cases say is, when you have a description of the property sufficient for identification, again, getting back to the project known as Millbrook Manor. And if I will, a very important point that I would like to point out to the court right here. Subsequent to this, GAFFKEN and BARRIGER brought a lawsuit to foreclose out and achieve this piece of property. They thereafter file a motion for leave to amend to join BOYKIN and close out BOYKIN's lien, saying, and I quote, after diligent review of the record title, we're now moving to close them out.
Was that after you did an amended lien?
There was no change in the description at that juncture, Your Honor. None whatsoever. The description was the same. And that's found at volume 3, 538 of the record.
What would be the effect if we assume, just for the sake of my question, that they had actual notice? They knew that your client was out there doing underground work.
That's my contention, Your Honor, yes.
So if we assume that the record in the public records specifically excludes the strip, so that if all I knew was I examined the title and I say, no, not in there. That's all I know. Okay.
In other words, the project known as Milton Manor did not appear there.
Right. Well, I'm not sure that I put as much emphasis on that, but just indulge me for a minute.
Yes, Your Honor.
If you examine the record and you come to the conclusion that this strip of property is not encompassed in the lien, but I have actual knowledge that your guys are out there digging ditches, putting in streets, and doing whatever is done on the property, what is the effect? What is the best case, if you've got one, or statutory provision that would say that affects the priority of their mortgage? If they have actual knowledge that you're performing subdivision improvements, but the record doesn't support that.
Yes.
The record doesn't support it from just a review of the record.
They do have a duty. And if you will look at the case of N. Ray CJW, that's found at 172, Bankruptcy Reporter 675, 683, the quote is, the court has previously noted that because the record notice constitutes constructive notice, which we know 71308 says a property description sufficient to identify the property is constructive notice, of the information contained in the record, as well as the information that would be discovered upon investigating all inquiries, now watch this, suggested by the record. Certainly Millbrook Manor suggests the entirety of this property, including what is inarguably the 3.6 acres within it.
So your view still, though, comes back to this document, and your view of this document is looking at the words Millbrook Manor suggests that I better go out and do at least an eyeball and see what Millbrook Manor is?
I wouldn't loan $700,000 approximate dollars without looking it over. So yes, particularly when it says Millbrook Manor, you have a duty to go. And the case law says.
But again, just so that I'm clear on your position, your position is that Millbrook Manor is broad enough to put them on inquiry notice, but the specific exclusion of the strip doesn't mean much. I mean, they still at least need to go out and take a look. Is that?
Well, Your Honor, with all due respect, my position is that that lien provides record notice, that they admit they had actual notice when they say, we looked at it, we decided to disregard it. Their subsequent filings demonstrate that the record revealed clear notice if they would have performed a diligent search, so willful blindness does not obviate their requirements. And not only that, they had implied actual knowledge by legions of cases, including a case cited by them, airflow, adobe brick, and maybe the most salient quote.
I want to just ask you a little bit about adobe brick.
Yes, sir.
If I'm reading this correctly, the meets and bounds in adobe brick were consistent with the notice of commencement and the notice of lien. So the only thing that was different was that the description, instead of saying Millbrook Manor, it said 250 Northeast 174th Street, Miami Beach, Florida, instead of 250 of 174th Street, Miami Beach. So the description was in error, but the meets and bounds was correct in adobe brick, correct?
Your Honor, that's not necessarily my read of it. When I read that, the court says the legal description was inaccurate. That's what it was provided to me, and as I read it, that the way the court interpreted it was, regardless of the necessary distinction in views, the court concluded that the legal description in and of itself was inaccurate, and it was salvaged by the fact that the project was named itself. Turning to Your Honor, Justice Orfinger's question, the case of Brooks Tropicals versus Acosta, found at 959 Southern 2nd 288, a 3rd District case. This is a quote. "It is too well settled to even require the citation of authorities that one who has either actual or constructive information and notice sufficient to put him on inquiry is bound, for his own protection, to make that inquiry which such information or notice appears to direct should be made. And if he disregards that information or notice which is sufficient to put him on inquiry and fails to conduct the inquiry and to learn that which he might reasonably be expected to learn upon making such inquiry, then he must suffer the consequences of his neglect." Your Honors, GAFFKEN admits they looked at the lien. They didn't conduct enough, and here's the other point that is very salient to the matter. Again, what more could my client have done? He did everything the law requires to perfect the lien. To require him to perform a title search is not what the law requires. Conversely, when they have noticed that they admit and acknowledge they have before even extending this loan, all they had to do was get a release of lien. It's a 2-paragraph document. They're the easiest thing in the world to get, and there's no doubt that this raises a suggestion in the record, Millbrook Manor, that there's a claim of lien that attaches to this. They acknowledge it, they admit it, all they had to do was get a release of lien and we wouldn't be here. On the other hand, my client couldn't do another thing. Now he's put $2 million worth of work into this property.
Counsel, I'm going to have to cut you off.
Thank you, Your Honor, very much. Thank you,
Your
Your
Honor.
Honors.
23 minutes.
If it pleases the Court, my name is Martin Friedman, law firm Rose, Sundstrom & Bentley, and we represent the appellee GAFFKEN and Barringer. And I would point out at the outset that when counsel is talking about actual notice, he's talking about actual notice of the existence of this document. He's not talking about actual notice of the existence that there was actually work being done on the property. There's nothing in the record that says that GAFFKEN and Barringer knew anything about what was actually going on the property.
Well, to me, one of the inquiries is this document, which on the front page says Millbrook Manor, is that enough to require further inquiry to determine what Millbrook Manor is. Now, I will, concede apparently that if you look at the description that's referenced in there, it specifically excludes this. So, title examiner is going to look at it and say, well, yeah, maybe it's there, but then when you look at the legals, it's clearly out. I guess the question is, if there's any evidence in the record to suggest that you all had actual notice that their trucks were out there digging ditches and putting in streets and clearing property, is that enough to defeat a summary judgment, at least as to that one potential claim?
But first of all, there's nothing in the record that suggests that the lender actually looked at the piece of property and knew that there was construction going on there. So the actual notice past the actual notice of the existence of this document is not relevant. And what I would suggest, Your Honor, is that in dealing with this issue of Millbrook Manor.
Well, let me just ask you, is it not relevant, or is it would be relevant if it existed, but you're suggesting that there is no such evidence?
Exactly, yeah. If they had raised it and said, oh yeah, we took these guys out here and we showed them this property and they saw these trucks and they saw all this work being done, then at least they would have that argument they could make. But there's no evidence or nothing in the record that even suggests that. So, the fact that there was work being done and the picture of all this work being done is really irrelevant unless there's something in the record, that suggests, hey, you ought to go look at this.
Isn't the nature of a claim of lien that there's work being done?
Yeah, but where is the work being done? That's the issue. And if you look at this legal description, counsel keeps saying, well, Millbrook Manor, it says Millbrook Manor, we should have looked at everything of Millbrook Manor. And I got a couple of arguments about that. Number one is that if you look at the legal description on the mortgage, and that's what they're giving the legal description, they give it to a title examiner and he takes that legal description. Nowhere in that legal description does it say anything about Millbrook Manor. It doesn't say Millbrook Manor, the project known as Millbrook Manor, more specifically described as, and then ascribing that 3.6 acre parcel. It doesn't say that. You wouldn't know by looking at this legal description and going to the courthouse and saying, all right, let's look at this legal description and see if this property is described in any other document. You're not going to find it.
Is there any record evidence that leading up to the summary judgment that your client ever had an appraisal or a survey done, or the owner of the property had an appraisal or a survey done to support the loan?
No, there's nothing in the record about a survey or an appraisal being done. And so we get back to the really, I mean, you look at it as a simple question. I mean, it's unfortunate that the circumstances where seemingly two innocent parties are getting, one or the other, two seemingly innocent parties are going to be harmed, and that's the court in the Page case, which I cited. That unfortunately is inherent when you have conflicts between the priorities of a mortgage and a lien. But if you look at the legal description is clear. It's unambiguous. It would have been ambiguous if it would have stopped where counsel says it stops. That party highlighted, the project known as Millbrook Manor, that might be ambiguous. But then it goes on to specifically describe by metes and bounds the property that's included. So I'm going to the courthouse with my legal description that my lender gave me to say, all right, here's the property that we're going to encumber. Go to the courthouse and find if there's any other encumbrances on that. And you go to the courthouse, and the metes and bounds description for the mortgage in question doesn't say anything about Millbrook Manor. And you go to a title search, and you see that there is, in fact, no encumbrance on that property. There's nothing in the record that suggests that we need to go look somewhere outside of the record because the legal description is unambiguous. And, many times in legal descriptions, they'll say so-and-so subdivision, as more particularly described. Because lots of subdivisions, maybe this one was not, but lots of subdivisions are developed in phases, in parts, and you'll see the name of the subdivision, and then you'll see that it doesn't really include all the subdivision, you're just selling lot 7. And so merely including the name Millbrook Manor doesn't put anybody on notice that they need to go out and figure out what the heck Millbrook Manor is, assuming that you even knew that by looking at the mortgage legal description. because the mortgage legal description doesn't say anything about Millbrook Manor. So how would they know? And Boykin's suggesting that GAFFKEN should actually visit the property and see all that work that was done out there is not what a lender is required to do. In order to be charged with matters outside the record, the court, as discussed in the airflow heating and air conditioning case that we relied on, that in considering the priority of a mortgage that was recorded without a legal description. And in that case, the mortgage holder recorded a legal description, and it said, as more particularly described on Exhibit A. Well, unfortunately, Exhibit A wasn't attached to the mortgage, but the mortgage is there, and it's from owner to mortgage company. Then the lienor comes by and puts a lien on it, mechanic's lien. And the issue in that case was what's the priority among the mortgage that was recorded and the lien. And what the court in that case said was the lien has priority because the mortgage, even though it says legal description on Exhibit A, there is no Exhibit A. So you don't know what that mortgage really encumbers. And just because it's the same person doesn't put you on notice that, hey, this person gave a mortgage to somebody on some piece of property, I need to go look and see if that's on this piece of property. They don't place that obligation.
Just so I'm clear, there's no evidence in the record that would suggest that your client or any of its representatives or appraisers or surveyors went to the property, looked at the property, surveyed the property, appraised the property, nothing that would give them actual knowledge of the trucks and clearing and all that stuff?
Absolutely not. Absolutely not. And there was an affidavit that, as counsel pointed out, that the principal of the development company filed, a long affidavit, deals with a lot of things, but doesn't say anything about implying that the lender or its representatives in any way knew that all that construction work was ongoing at that time. Boykin relies upon a plethora of cases that the lienor is only required to provide substantial compliance with the law. And of course, while that is true, it's not true, as pointed out in Section 713(4)(a), where there is an adversely affected party. And obviously, in this case, the error in the legal description certainly would adversely affect the subsequent lender, because had that legal description be correct, then obviously they would have dealt with it, as counsel said, one way or the other, either not make the loan or gotten a release or done something. The legal description of the lien is clear, it's unambiguous. There's nothing in that legal description that would suggest that there's any further inquiry that's necessary. And then again, as I pointed out, there's nothing in the mortgage legal description that implies that it in any way deals with any part of something that may be called Millbrook Manor. And the counsel mentioned this new case that he filed as substitute authority. That case doesn't involve a disagreement over the priority between the lienor and the mortgagor. That case is between the owner and the lienor, and obviously the owner knows what property he owns, as the court pointed out, and so those type of legal description errors between the owner and the lienor are overlooked. And that's the same as all these other cases, is that when the case involves a dispute between the owner and a lienor, obviously the courts are going to overlook those errors in the legal description that the owner may make, because the owner knows what property he owns. And that's what those plethora of cases that were cited, and also the supplemental authority that was cited. And based upon that, Your Honors, we would respectfully request that the court affirm the lower court's ruling. Thank you.
Good. Thank you, counsel. Mr. Beaver, I'll give you a minute for rebuttal if you like it.
Your Honors, if you look at the airflow case, it flatly supports our position when it quotes and says, "We are not unmindful of the proposition that reference may be made to a recorded document or deed. A creditor or encumbrancer is thereby placed on notice by the reference to such other deed or document. If a reasonable and prudent person would be apprised of the existence of a right by reference to another document, or reference to another document can supply what clearly and reasonably appears to be an omission or defect in an essential part of the recorded instrument, then notice is presumed as a matter of implied actual notice. Your Honors, this lien references the contract, which is a document. It references the project. It references the parties. That complies with the law. If you look at Sasso in my brief, Sasso plainly says, once that the contract is listed, it's sufficient. Johnson versus Bailey is a case where there was no property description whatsoever, but it mentioned the contract. And the court said, as a result, that is a sufficient description to put any subsequent followers on notice. He touched on an important point. Talk about adverse effect. As I've described through the Acosta case, it's impossible for them to claim adverse effect. You can't walk into the room with knowledge that the room is problematic, dangerous, or otherwise and say, I'm not bound to the adverse effect that comes with walking in the room. The case of Johnson versus Bailey says, failure to include a description of the property when the lien was originally recorded was a failure to substantially comply with the lien law. This is Johnson versus Bailey, which I just articulated. The court said, we cannot accept this argument in light of the clear language that an omission will not defeat the lien without a showing of prejudice. Adobe Brick says, the intent of and purpose of the mechanics lien statute is that omission or error in a matter required to be stated in the claim of lien shall not operate to prevent enforcement as to one who has not been adversely affected. 12 Oaks.
I'm going to have to close you out there. You've exhausted your time. Thank you very much.
Thank you, Your Honors, very much.